Good morning, good morning. The the attendance list is circulating. It's 11 o'clock, I believe, is it? And we are already in week 4, so we finalize the introductory themes. And as of next week, we will devote 4 weeks, as we say in modern Latin, capita selecta, so selected chapters. But before we reach there, we need to finalize the last 3 additional aspects of corporate law, the aspects we will discuss today and which are introduced in the course description and that are additions to the 5 core aspects. What I would like to introduce on top of the metaphors already introduced to you is the metaphor we will need in a bit on thinking, deciding and doing. That is, that within the undertaking there are processes going on, we discussed that, especially in the brains of the owners on the course of actions. But the thinking as such, strategies and the like, is not material, is not legally of importance. The second step is the decision making. And when we use words as decision or resolution or similar words, we talk about the decisions that by law are binding to the corporation, and the organ that is appointed in the selected jurisdictions is the delegated management. So delegated management is the decision maker. All the other considerations of shareholders, etc., are not material where it comes to the legal person, the enterprise itself. And then the last step is, let's say, the dirty hands, the actual doing. So the actual production of products and services and the sales, etc., which are, by a mechanism of law, attributed to the legal person. So when your cashier in your supermarket receives your money, that is a sort of action. That's not a decision, that is an action, in the sense that whatever she receives as an employee is on behalf of the legal person. How is that legally arranged? By specific legal rules to that extent. In normal human being language, whatever an employee is doing is attributed to the legal person. Dot. One way or the other. And we will need that distinction later on. So, last week we discussed assets and finance, and now we will deal with the remaining 3 of workers' innovation, production and sales, and regulation and compliance. And with regulation and compliance, chapter 7 pops up the mandatory reading of this week on security markets regulation. As an example, how legal regulatory frameworks are influencing the doings of a corporation. So we will discuss it. All right. Innovation and workers, or workers and innovation. So this is the sort of acting part in the metaphor I just introduced. So this is not about decision making, but this is about making turnover happen. So the lowest layer in the metaphors. And we will discuss the concept, the law, and some examples. We look at workers from the, or in a corporate setting. So we are looking at those workers, in this case, as participants in the corporate life. And there we have two sort of key roles. The first is co-management, as we had an example in the workshop lecture last week on Adidas, that employees are part and parcel of the board. So there you see a double role, worker in the sense of producer and of decision maker, and the so-called co-determination, and that is influencing the decisions, which are in the basic scheme restricted to the board itself. So here we look at workers in their, not their pure productive phase, that is not that interesting from a corporate law perspective. There they are comparable to robots. Sorry for the parallel. They just have to function, produce value, shut up and work, in a sort of non-Dutch way of looking at workers. And here we look at workers where they are taking up roles that are by law reserved for the board. So that's one. Two, pertaining to those workers, we have classic employment law issues. In a course like this, that is just by way of reference, this exists in the sense that legal departments of corporations, where you have to deal with, devote part of their time on on the individual employment contracts, on the dismissals, on those collective rights based on union negotiations quite often, as in salary levels, amount of days off, bonus pays, etc. And in the sense of transfer of undertaking, we will discuss. So two perspectives, and this is traditionally called labor law or employment law. And why do I mention that in this stage? Well, because they spend part of their time on those questions, and you as managers or shareholders or whatever role you will get have to share their brains, because for you they have to draft contracts and decision making and thinking processes, as for instance the general meeting of shareholders, etc. So those are two distinctions. And then the last one is related to workers, as in that the workers create the value, and one way of looking at that is that in the successful cases, that value could also be labeled with innovation. They do something creative. We mentioned last week the highly successful trade 100 years ago in ice blocks, and then we have an innovator somewhere in history who invented the refrigerator. So when you look at workers that way, there we have three additional perspectives. One is workers' obligations, that if you're an employee of a corporation, whatever you invent, whatever you produce in value, is of the, or belongs to the enterprise. And there are two ways to achieve that. One is that you put that rule in the local labor law, as in whatever the worker invents belongs to the institution/enterprise, or you put it in the individual labor agreement, that you agree with the employee if you, during your job, invent, smartphones or financial instruments or whatever in between, then we agree that that belongs as property to the undertaking. And then obviously there are interesting gray areas. What happens if the employee invents clever things in the evening? Is that still belonging to the enterprise or not? So there you could have multiple beautiful disputes, and then local law on and around innovation settles those disputes. Another way of innovating in enterprise is that you purchase a other company that already invented the product or service you want. And that is how all the big companies we know, including Facebook and Amazon and Apple and the banks, you probably heard many guest lectures on fintech already. Is that the case? Fintech?
And what it is.
So technological innovations around financial services in the apps, etc., etc. How do big players, big banks who exist for hundreds of years, innovate? They purchase those little companies that invented an app or this and that. And then the key word is mergers and acquisitions or joint ventures, that you join forces with another company, and then from a heuristic perspective, from a legal perspective, that is then based on contracts. So based on contract law, see the other course, you negotiate and then agree that the innovations of that other party is then yours. And then a third aspect is traditionally dealt with in a course with names like intellectual property law or names like that. That is then, how do we protect such an innovation from copying by the competitor? So first you have to invent it yourself, your own employees, or you buy it from a small company to integrate in your bigger company, or, not or, and then you want to protect it. And then in the enterprises there are three sort of avenues. One is the patent. Patent is on a new, innovative, technological innovation, which then could be protected as in that you get the exclusive rights for 20 years on average. And during that 20 years, no one else is allowed to use that particular innovation. That is sort of mind-boggling. So if you invent a medicine against, let's say, cancer or depression, where you could say from a societal perspective, whoa, that is good, let's use it collectively, and then during 20 years, only that inventing company, through the employees, is entitled to exploit it, or not to exploit it. And so that is very strict. Secondly, the trademark. The trademark as in the name of the product, and the function of a trademark from a legal perspective is to identify the maker of the product and services, and in that identifying, trust is embodied. So if we see a Apple, or if we see Hewlett-Packard, then the brain functions as follows, that we think that is a trustworthy producer, and therewith this product or service is trustworthy and worth the money. And this is on your balance sheet in the left upper corner or left lower corner, depending on your accounting standards, the intangible assets, and then there are these valuation rules that sometimes companies consist of 80% of that intangible value. So that the name as such, Coca-Cola, Microsoft, is having more value than the plants and the raw material, etc. And then those are for enterprises the most important ones. Then we have a few other types of intellectual property flavors, including copyright, that is for music and movies, and for Walt Disney and other stock market listed companies, equally important as patent. Rights on seeds, tulip bulbs, so a variety of industrial products and services have sort of tailor-made protection mechanisms. And this is also an area where your corporate lawyer, your colleague, will have to spend time on, which finishes the sort of legal building around your enterprise. Okay, so those are in the topic workers and innovation, the key areas, and then we pick today just one, no, two, and that circles around those workers. And let's start with the co-management. So we have two flavors, co-determination, co-management. Co-management is participation in the board. That is, that an employee, as employee, so a human being that is also originally employed by the company, is appointed in this body called board or directors or management, which is, from a corporate law perspective, this delegated management. So a sort of von Münchhausen type of activity that by the operation of law, these representatives are in the board, which you could also call positive discrimination. So from a shareholder's perspective, investor-owner perspective, you would opt for the best person on the chain. And then we have all kinds of considerations of composition of that board. Most importantly, obviously, men and women, which is lousily realized in terms of statistics on the globe. And here we have another type of positive discrimination of workers. In the global division of regulatory traditions or jurisdictions, this is not equally divided. Or more concrete, in Anglo-American jurisdictions, this does not exist. In European continental jurisdictions, this does exist. So here we see a quite extreme difference between the jurisdictions we touch upon in this course. So here we zoom in on the European Union and more specifically on Germany. In the European Union, we have this Societas Europaea, a legal person that is created by the EU itself. So that is a sort of limited or BV or NV, but then of EU nature. And that phenomena is introduced by Regulation 2157 of 2001. And in that regulation, a failed harmonization is introduced of workers' co-management. So in that regulation, it is suggested when you create your articles of incorporation, your charter, that your house rules, that you voluntarily adopt this co-management. In the early stage, in the 70s, there was an attempt to make a harmonization in this direction, meaning that all the now 28 member states should have a mandatory legal environment in which all the public companies have co-management. And that is voted down. The source is Germany. And in Germany, based on a sort of social democrat type of approach to economy, and they already in the 50s introduced this co-management. And one of the sources is Article 76, and then BETRVG is the abbreviation of the Betriebsverfassungsgesetz, which fairly translates to the governance law, corporate governance law in Germany, which this is a sort of the original legislation, and now partly it is transferred to the corporate law in general. So the source is a sort of moving target, obviously. But just to give you an idea what one of those sources could be. And in that Article 76, it says that a public company should consist of X% of employee board members. Dot. And so a full swing percentage requirement pertaining to a type of individual appointed as board member with a specific characteristic. And I liked this example because the current discussion is about other types of positive discrimination. And one of the arguments of the against camp is, well, we cannot force companies to select specific type of board members because that is, in the key aspects of corporations, the realm of the shareholders. They must be completely free in deciding who is their delegated management. And that argument is not valid because quite a few jurisdictions have such a rule that there's no such a freedom to decide whatever you like in terms of the composition of the board. So it is a very small step to say, well, let's apply the same rule to women. So 50% should be women or other members of your society who are underrepresented. And so from a technical, legalistic perspective, that is extremely easy and done before. From a societal and acceptance perspective, we are not even close. But just to indicate to you that it is not the lawyers that are the obstacle for equal representation. We did it before with employees. No one complained. Well, they complained, but they said, okay, if you, society, wants sort of co-management, here you are. Important. Example, Adidas last week. And then, more mainstream, co-determination. That is harmonized. So, all the 28 EU member states in their corporate local law have this implemented. And I pick two aspects, and that is advice and consent. So all the 350 million workers in Europe have, through their works council, comparable to your student council, sort of equivalent, two key rights. One is the right to advise, who? The management. And two is the right to consent. So in the previous weeks we had consent, decision rights of supervisory boards on certain decisions. You know, those major decisions. And here we have, bottom up, the same consent, but then from the works councils. In the Netherlands, we have a work council law, which is not included in the civil code. Could have been, but this is sort of standalone law. But you have to see that as part and parcel of Book 2 of the Civil Code, because it is about decision-making processes. And there, it is Article 25. And that means, down to earth, that if the delegated management, so the official board, wants to make a decision on a dismissal of more than 10 employees, or the closure of a branch, or all kinds of other decisions that affect the work of the workers in the company, and there are thresholds, you know, more than 50 employees, so not the bakery on the corner, but only bigger companies, but you know, all the companies we discuss fall in that definition. And then advice is a three-step process. One is the delegated management, the board, needs to send the concept advice to the work council. So imagine yourself making all kinds of decisions in the drafts, annual statements on December the 31st, and you need to be ready by the 1st of January, because you have to first send the concept decision to the work council. And they need, 48 hours, 2 weeks, depending on the type of decision, to develop a advice. That advice is step 2. And then 3, the delegated management needs to reflect on that advice. So it is not that you are allowed, by law, to send this concept and just go ahead. Work council, shut up and work. No. You have to receive the advice, and then in the final decision, you need to reflect on the advice. But it is an advice, so with reasons you could put it aside. But you have to then argue, like a sort of judgment. Ladies and gentlemen, we talk about a business. But as a sort of judgment, you have to reflect on the advice. So you have to say, you have to spend words on it. As in, we received the advice of the work council, we are very happy with our insight, but due to social economic turnover considerations, we cannot afford to keep all those employees. Legal consequence. If the workers are dissatisfied with the final decision, that is step 4, they can go to court. What can the court do? The court is not on the seat of the entrepreneur, the board. But the court can check whether the board lied. So if there are no economic reasons to dismiss, why? Because there's a huge pile of cash, or for instance, and you said, well, we are poor, so we cannot afford it, and that is a lie, then the legal consequence is that the decision, the court can order that the decision is annulled. So a 4-step sort of boomerang mechanism in the European Union pertaining to advice. And then on a very few topics, there is this consent right. So don't exaggerate that in your head. That is only if the enterprise wants to close its doors. We discussed that in terms of the liquidation. If you decide, well, I don't want to produce computers anymore, like Apple, and you want to close the corporation. So the major type of decisions, there they have a sort of consent right. But that is not so material. Imagine in the advice region that you want to merge, Bayer wants to merge with Monsanto. That is definitely one of those decisions where the workers have advice. And if step 4 means that it is annulled, then you better make sure that you take step 1, 2 and 3. Otherwise, 3 years later you hear that you did not decide to merge with Monsanto. And then you have to reverse 3 years of steps, You have to take apart the logo and so forth and so forth. And so that is sort of dynamite. Quite interesting co-determination. This is of interest of employees, and since you are employees, this is interesting. All those jurisdictions have some sort of employee protection, even the United States of America. And we always live in this caricature that you can be dismissed in the United States at your feet without any consequences. That is not true. But the level of compensation, etc., is different per jurisdiction. This is the Netherlands. 2 flavors. The district court may dissolve the labor contract. So you cannot do that by yourself as employer, but you have to go to court, and then the court dissolves sort of divorce type of procedure. And the other one is a license, a complicated system, overcomplicated system in the Netherlands, that a sort of government agency provides licenses for dismissal, which sort of works the same as this dissolvement of the court, but a little bit different. And then, most importantly, second aspect of employee protection, a severance pay, a payment, and that is a euphemism, transition allowance, it's called in the Netherlands, which means a sum of money to compensate the loss of your job. Interesting for you, 2 articles you have to look at when you are employee yourself. And then, also harmonized in the European Union, to avoid all this messy employee rights, the best thing to do is to purchase the assets of a other company and dream that you are not have to bother with all those employees, and that you create a new legal entity, you put the assets in, and you start all over again with new employees. That is what an entrepreneur would think if he or she is confronted with all those protective mechanisms. And that is blocked by a regulation, and that is in the European Union, implemented in the local jurisdictions in the Netherlands, Article 663 of Book 7, which says that when you purchase all the assets and services and clients of a other company, you are forced to take all the employees of that company. And that is mind-boggling, but in the European Union, the standard. So there is no way around all these employee rights. And the key word is then safeguarding employee rights. And the event is transition of employees. So then you get the employees, which were not your employees, but when you purchase, for instance, a trademark of Apple and some customers, then you get all the employees. Yes?
But along if it's according to law, there are rights that are not that binding, I assume.
Yes, this is extremely binding. So if you if you purchase another company, the legal person, the shares, then we are already accustomed to the ID. Then you get everything of that company, you know, all the assets, employees, clients, etc. If you are not buying the enterprise but just the valuables, then this law makes sure that you get also the employees, and that is then binding, all of them.
Yeah, but I mean more in the sense, okay, you did that according to law, and then later you close a branch, you did the conceptual thing, you had to consent as far as possible, and you had the
yes. Okay, so if your question is that the end of the story? No, then you could restructure that new branch, that new daughter, that new activity, but then you have the other employee protection. So let's say, especially in continental European countries, the UK the same until the Brexit, that employee protection is quite high. And so that is not something you are interested in. Okay, and then just as an example of the patents, the intellectual property landscape is sort of scattered. We have international protection, we have European protection, we have local protection. Protection means laws that specifically say that in that jurisdiction you have this type of protection, ABC, and this exclusive rights. And I would like to sensitize you that in the Netherlands we have this European Patent Office in The Hague, Rijswijk, but that is not a EU institution. So the funny thing is that when you look at European Union law, that only flies if there is consensus among all 28. And pertaining to intellectual property law, there is no such consensus on all the nitty-gritty of a legal framework. And that means that you see that a selected a selection of member states take a further step, not via Brussels, and create a convention, European Patent Convention, with a mechanism. And so don't confuse membership of these types of harmonization mechanisms with the European Union. And it has a sort of bearing on stuff you already know, including whether you could go to the European Court of Justice in Luxembourg, yes or no, etc., etc. So that is to indicate that the EU is, in that sense, complex. And then the most popular and easy accessible intellectual property right are trademarks, because there the harmonization is fairly transparent and uniform, in the sense that the international protection mechanism, the Treaty of Madrid, has almost the same wording as the European Union harmonization of local laws, which are then, by definition, or not by definition, but in this case, almost identical to the local wording. And the wording is that as a owner of a trademark, you know, Coca-Cola or whatever, that you are allowed to prevent all third parties from using it. And then you have the discussion of whether the sign is identical to the original. That's easy. More complex, whether the sign is similar to the original. Starbucks, Starpreya, Exxon, FX. And then that is, from a lawyer's perspective, quite interesting, because then the question is Chica Loca a, which in that language is sort of funny saying, is that a infringement of the trademark? It's not identical, but it is similar. So let's say, who would, as a judge, regard that logo and assume that Chica Loca is a sign on a drink of a dark color? And you have this sort of refrigerators and a bar, and then you have Chica Loca and then Coca-Cola. And then as a customer you say, I want one of these. And you think, well, I get Coca-Cola. The danger of confusion, or the likelihood of confusion. So who would say that there's not such a likelihood of confusion and that this should be allowed? When? And who think that there's this likelihood of confusion and that there's a free ride on the name and fame of Coca-Cola? Okay. And here the same, Starpreya coffee, Starbucks coffee. You really have to look very closely to see the difference. And so who think that this is allowed, that capitalism brings with it that you can get very close to each other in terms?
Yeah, but it's not about if it looks alike. I don't know how you call the phrase again, but you have the right, like, to not copy it, but to like make a pun out of it. You have the right to do so. And I think there has been a ruling about that with Starbucks. I don't know if it was the.
Oh, definitely. This is from a court case.
And I think they were allowed to have that wink towards the. They made the joke out of it, looking like Starbucks. But
yeah. Okay. So you have a satire. Yeah. But this was just a coffee company. So who think that the judge allowed this company to have this logo? Who think that the judge denied that right to the Starpreya company? Yeah. And so the function of the trademark is to identify the maker of the product. And then you confuse Starbucks with Starkrea if you do not pay attention. And if you're traveling, you know, on the airport, you get confused, etc., etc. Well, and this is already more complex. So assume that they produce oil for scooters, and they are just a gasoline company. Yeah? That is already a little bit more or less similar. So who think that FX is allowed to sell scooter oil in a shop? And who thinks that FX should not be allowed to do so? Okay, so good luck for FX. Yeah, so in this jury, we decide. The reason that I emphasize this innovation part and the protection is that is at the core of your conversation when you meet as entrepreneurs and you start a business. You're very happy that lawyers will take care of the articles of incorporation and the charter, etc., etc. And the real topic you get excited about is your product and the name of it and how it should look like. And what I indicate here is that also on that point you have to be aware of legal nitty-gritty. Very quickly, prior to the break, we have products and sales. There are two phases when it comes to regulation. One is the design and the production of a product, where there are multiple regulatory frameworks, for instance in pharmaceuticals, in terms of you need to test it 10 years in this way, and then you get a approval stamp. So where it comes to production and design and production already. And then secondly, in terms of the sales, that is contract law, you are bound by a variety of regulatory obligations you met in the course on contract law, keyword consumer protection. And then, most importantly, at the end of the line, there is this non-contractual liability for faulty products. And that non-contractual liability, or product liability, means that if you produce a little van of a engine, and that engine, and you sell that van to the company Rolls-Royce, and Rolls-Royce makes a plane engine, and Rolls-Royce sells that engine to Airbus, and then Airbus connects that engine in their plane, and then that plane is sold to Air Italia, and then Air Italia is leasing that company or that plane to Air Berlin, because they have too many planes, and then they paint it over. And when then the Air Berlin plane crashes, and the causal link, remember, tort law, the causal link of the crash is the van, then that little company in Delft creating this little van has product liability, and is liable in the European Union, harmonized rules, is liable for all the injury damages and damages to the belongings of the passengers and the companies owning the plane. That liability has a very strong effect reverse-wise to the design and production phase. Because if you know that your stupid little van in an engine can create major liabilities, non-contractual liability, you pay more attention. So here we see an example in this further aspect of enterprises that a simple rule on product liability in the European Union is influencing design steps, so at the early stages of a life cycle. I say European Union. Well, the funny thing is that producers in the United States of America, in China, in Brazil, they produce for a global market, as the EU produces for a global market. And that means that this EU legislation has an effect on van makers in China, United States of America, Brazil, etc. So the funny thing of the global marketplace is that those local laws in the Netherlands and the 27 other member states have an effect on also non-EU enterprises. And this is then in the Netherlands Article 185 of Book 6, where it says that the producer is liable for damage caused by a defect in his product unless, well, all kinds of conditions you are familiar with based on the other courses on law. One of the examples is unless no one on the globe could foreseen that this type of defect would occur. And then, based on this thinking, and in the United States of America there's a local version based on regular tort law, this is an example out of millions of examples that enterprises do not want to litigate for 20 years on such a question, so they make settlements. So injured parties join forces and a collective action. We know that from movies, Ellen Brockovich, all kinds of other type of Hollywood representations of this phenomena, and then corporations pay a settlement payment to the injured parties. And this was about breast implants that were rupturing, so faulty products and not well designed, and all the injured clients sued Dow Chemical, a huge American pharmaceutical and chemical industry. Not that those women had a contract with that company, no, that material was sold to a breast implant plant, and that sold it to the hospital, and then the doctor sold it to the client, the patient. And so a long chain, so no contractual relationship, but you skip all the parties in between and you jump directly to the producer of the faulty product. So in the EU, with quick and dirty rules, the producer is liable. In the United States, this mechanism based on case law, that if you do not pay, then you will be regarded liable anyhow, if certain conditions are met. And the condition is, for instance, and that is quite often the case, that those producers knew that this risk existed and nevertheless continued in producing it in the way they did. And the beauty is, in terms of evidence, that those considerations are always laid out in emails and notes. And that is why there are these dawn raids that with public authorities, or in the United States with private parties, you can seize evidence. And then they seize hard disks. And then there are always these memos of the concerned employee. Dear boss, I think this is a bad product because the last 6 of the little thingies exploded in my hands, so please do not produce it. And then the entrepreneurial decision is, well, we can make money with continuing on the path we started on, and that is then sort of the issue around all these questions. I think, based on the time management of this lecture, that we deserve a 11-minute break. In that break, I will start making a doodle enrollment tool for the oral presentations, which I will then open up at, let's say, 4 o'clock this afternoon. So after the lecture you can team up with your partner and make sure that you have the preferred slot, so that as of next week we can start the presentations. And if there are questions on that, we could discuss that after the break. So first we can collect some questions.